right, thank you, Kelly, for that introduction. Like she said, my name is Jeremy Hayes. I am the director of the Tenfold Housing Rights and Resources Center. We are the designated FIP, or the Fair Housing Initiatives Program, for York County. We have a education and outreach initiative grant from HUD to do education and outreach in fair housing to tenants, landlords, service providers, anybody who is curious or needs to know the information. So let me share my screen real quick. One, and then this one. There we go. So if you do have a question, feel free to put it in the chat, in the chat, and I will do my best to answer them.
Jeremy, just so you know, we are seeing your kind of back end display side. This happens to me all the time, so I just wanted to let you know.
Let's do this one. Is that better?
That's better. Perfect. Thank you.
Second time. All right. So let's get started. We're going to go over a 30,000-foot view of fair housing law at the federal, state, and local level today. To begin, this is our broader continuum of services at Tenfold. In York County, we don't have the emergency housing or supportive housing programs, but the Housing Rights and Resources Center, that's me, that's us. We are very active in York County, our Financial Empowerment Center for budget, credit counseling, first-time home buyer stuff, that is also in York County as well. So please, if you have any clients that are looking to better their financial situation, buy a home for the first time, reach out to me and then I can get you connected to the right person for that. Today, like I said, we are going to go over fair housing law, federal, state, and a little bit of local. We're going to go over what dwellings and residences are as well, since fair housing law covers dwellings and residences. I'll talk about some examples of discrimination, what it can look like. And then after that, after we talked everything about discriminatory impact, we'll go into some disparate impact. And these are policies that housing providers, that municipalities can put in place that at their face value are not discriminatory, but have a discriminatory impact on a certain protected class or population. And then lastly, I will go over some exemptions to fair housing law, because it doesn't cover everybody. So why is it important to know this stuff? First off, because if a landlord, if a housing provider is found to have violated fair housing law, that complainant is able to get damages, able to sue for damages, and that's actual damages. So if the tenant had applied and was denied, and they had to have hotel fees, they had to stay in a hotel, they had to go out to eat because they didn't have a refrigerator, they had to send all these other application fees in when they would have just been approved originally for that first unit, they're able to be reimbursed for that stuff. Those damages can be awarded to them. It's also damages for humiliation, emotional distress, and then at the federal level, a housing provider can be charged up to $21,000 for their first violation, and then as you can see, it goes up from there. So just make sure you know what fair housing law is, what it says. Ignorance is not an excuse here, which is why we're here, which is why we do what we do. So the fair housing law is a combination of the federal fair housing law is a couple different ones. It's the Federal Fair Housing Act of 1968, Section 504 Rehabilitation Act of 1973. At the state level, it is the Pennsylvania Human Relations Act, and that is managed by the Pennsylvania Human Relations Commission. And essentially, these laws state that it prohibits discrimination in the sale, rental, lease, or financing of dwellings based on a person's race, color, religion, national origin, sex, including sexual orientation and gender identity, familial status, and disability. Then at the state level, they add age over 40 and ancestry. A lot of localities will have their own fair housing ordinances, but they can only be more strict than the federal or state level. If there's a local locality that doesn't want to protect disability, you're still protected at the state and the federal level. So they can't negate or nullify any of the other protected classes at those higher levels. So we do operate in Lancaster as well. So Lancaster City, as an example here, adds to their fair housing ordinances, specifically guide dogs or support animals. They specifically add possession of a GED. They have ancestry on here as well. And they also spell out sexual harassment, gender identity, and orientation. And then in York, they also have they spell out marital status or pregnancy specifically. That usually falls under familial status. They also spell out guide dog and support animal. They have creed on here as well. So as you can see, it's more strict. It adds classes, adds protected classes to the laws essentially, rather than taking them away. So fair housing law covers dwellings. If it's not a dwelling, it's exempt from fair housing law. So what is a dwelling? Fair Housing Act describes or defines any dwelling as any building, structure, or portion thereof which is occupied as, or designed or intended for occupancy as, a residence by one or more families. A HUD regulation promoting discrimination on the basis of disability then defines the term of dwelling unit as a single unit of residence for a family of one or more persons. So that's a dwelling. So what are some examples of dwellings? This is dormitory rooms, sleeping accommodations and shelters intended for occupancy as a residence for homeless persons. Some are bungalows, cabins housing migrant farm workers, nursing homes, university student housing, timeshares, hospice, and the list goes on. So it's not just a rental unit. It's not just a house with a landlord with a lease, that sort of thing. What is specifically not a dwelling? Motels, bed and breakfasts, and jails. There's more on that list, but these are the big ones. If a motel or a hotel does have an extended stay portion, with a signed contract that they pay weekly, that can be considered a dwelling at that point. And it does fall under the Pennsylvania Tenant Landlord Act, which is separate than the fair housing law, and it also falls under fair housing as well. But it's a regular, going up to a Marriott to stay for the weekend. That is not a dwelling. So to determine if it is a residence or a dwelling, the terms can be used back and forth. You have to ask a couple of questions. Is the facility meant to house occupants who intend to remain for a substantial period of time? So obviously rental housing, those are usually year-long monthly contracts. They meant to stay there. For shelters, it can be a little bit tricky. Those overnight shelters where it's up in the air of who gets there, first come, first serve. Those are typically not a dwelling or a residence. But if it's a longer stay shelter, has case management, is that person as here, do occupants view the facility as a place for which they can return to? So they can return to that room is theirs, that space is theirs. Do they treat it like a home? Do they decorate? Do they clean their room? Do they cook their food? Do they receive mail? All of these questions need to be looked at. A few other questions is do they have their toothbrush there? Do they put their clothes away there? Do they leave things back behind in their room that they intend to return to? Those longer stay shelters, they can be considered a dwelling or a residence and would fall under fair housing law. There is no hard, fast rule about it, so you have to look at each one on a case-by-case basis, but it is safer to abide by the fair housing law if you're not sure, just because, like I said, ignorance is not. I have a question here. I'll get to that in a second. It is not an excuse for the violation. So question, does support animal under these laws include registered emotional? So we are going to go over that specifically in a little bit here, Sam, but the short answer is yes. So now that we know what the laws are, what they say, and we have a better idea of what they actually cover, residences and dwellings, what does that discrimination actually look like? It's very rare these days that a landlord or somebody is going to say, well, I don't want to rent to anybody. Well, I am Christian. I only want to rent to other Christians, no Jews, no Muslims, just Christians. That's very rare, mostly because people know that you can't do that. So what does it actually look like? Just these are some broader examples. So just refusing to rent or sell housing, refusing to negotiate, making it unavailable, or denying a dwelling. All of this stuff is pretty much an example of that application, right? Somebody's applied and they just never get a call back. Or they call and say, well, it's already been rented, I'm sorry. That sort of thing. It's harder to determine the fair housing violation in this case, but you don't need concrete evidence to file a complaint. You just need a feeling. So maybe somebody's calling, a client calls, they don't have an accent, but they are of a different national origin. And then it doesn't belay that at all either. Landlord's happy to show them the unit. He's great. Yeah, come on over. You show up with the client. Instead, the landlord is more standoffish. They're asking where the client's from. They're trying to figure out how long they've been in the country, and then you never get that call back. That right there, if the client is feeling like, well, he's probably because I'm brown, or I'm from the Congo or somewhere else, Puerto Rico, something like that, which isn't another country, but just an example. That could be a fair housing violation, and then they could file a fair housing complaint based on that. Setting different terms and conditions, that's requiring a double security deposit from a family with 2 kids, but not a single person. Same with requiring a double security deposit from a Black family, but not a white family, something like that. Additionally, making them wait for maintenance, not going over to somebody's home to perform maintenance. More often than not, that can be the case. We just had one example where there was a domestic violence situation, and the landlord didn't want to go do maintenance because they were worried that this individual was going to file a domestic violence case against them. And so that would be an example of different terms and conditions. So provide different housing services, same deal. Normally, you would just go in and do the maintenance with that example, but in this case, the landlord's requiring a couple different extra steps for this tenant. So steering and block busting. Steering, I like to try to think the best of people here. So steering, I say, can come from a good place. This can look like, oh, well, you're Spanish speaking. So most of my Spanish speaking tenants live in this section of the complex or this section of town. So I'm only going to show you those units. Or, hey, you have kids, young kids. I don't want them to fall off this second, third floor balcony. So I'm only going to show you the ones on the first floor. Or I see you walk with a cane. I'm only going to show you places on the first floor because I don't want you to have to go up the steps. That's the landlord coming from a place of concern for the tenant, yes, but it's not up to them. It's up to the person with a disability to decide if they can go up steps, to the family to keep the child from falling off the balcony. So they can, if the tenant comes up, the applicant comes up and says that, hey, I only want to look at first floor units, or hey, I only want to look for a unit close to other Spanish speakers. That's fine. That's the tenant making that decision. But it's up to the tenant and not the landlord. And then here, refusing to make reasonable accommodations or modifications. These are specifically for those with disabilities, and we will get into that in more detail further on. Advertising can also be illegal, examples of discrimination, which would make it illegal. So saying things in an advertisement like no kids, perfect for a single or a couple, Christian home, not suitable for a person with disabilities, a good Italian neighborhood, that sort of thing. All of these things denote that certain protected classes shouldn't go apply there. What if I'm not Italian? Do I not go into that neighborhood? What if I'm not a single or a couple and I have kids? What if I am have a disability? You're specifically stating that those with disabilities should not apply here. As the tenant, it is my decision and my choice if I should not apply there or not. So that's something to keep an eye on. And even when we get to the exemptions, Advertising is not exempt from fair housing. So even if you are a exempt individual, exempt housing provider, you cannot discriminate in your advertising. So here are some examples I put on about discrimination exactly. So a for rent sign saying 4-bedroom home available for a God-fearing family. What if they're not religious? What if they're atheist? What if they're Buddhist? Then they can't exactly go rent there. I already gave the example of falling off a balcony for small children. That, again, is up to the family. If they're concerned about that, then sure, first floor units. But if they're fine with the balcony and not concerned, as a housing provider, they need to be shown those units. Here's another example of the discrimination based on disability. You walk with a cane, so I'm going to show you a unit closer to the laundry facilities in this complex. Again, it's up to that tenant if they want to be closer. I mean, the idea is that yes, they'd be fine with being closer, but it's up to them to decide that. Here's another one for shelters here. If it is designed as a dwelling or determined as a dwelling. I can't live in the shelter because you have an oxygen tank, and I'm worried it will cause damages. Maybe there's a policy on compressed gas that's really intended, and this could be a example of disparate impact, but it could be intended for people not to have those propane tanks in the home for grilling, but it has a disparate impact on those with an oxygen tank. So that could be an example of discrimination based on the disability. So speaking of disabilities, what is it? A handicap or disability is an individual with a physical or mental impairment that substantially limits one or more major life activities. It is an individual with a record of such an impairment or an individual who is regarded as having such an impairment. So that's as simple as a landlord or a housing provider stating they're crazy. They're not all there. I know they're not all there, kind of thing. Well, they are being, even if they don't have a mental disability, that housing provider is regarding them as having a mental disability, and thus is treating them that a different way and is violating fair housing law. What is not a disability? A disability is not somebody who is currently using illegal substances. If they are recovering from these illegal substances, that could be considered a disability, but not current users. It's also an individual who poses a direct threat to the health and safety and property of others. And direct threat is in quotes there because it cannot be a perceived threat. Oh, this person has a mental disability that typically results in violence or destruction of property, so I'm not going to rent to them. I'm not going to let them in the shelter. No, you have to be seeing them do the harm in front of you at the moment, at that time. It cannot be perceived. So under fair housing law, people with handicaps and disabilities do have the right to make reasonable modification and reasonable accommodation requests in order to fully use and enjoy their dwellings. Arrow. There we go. Cool. So, excuse me. These requests can be made verbally or in writing by a tenant or a representative of the tenant. So if you guys have a client, you can make that request as well. It's always better to do it in writing, but once a landlord or housing provider hears about the request, they need to start acting on it. They need to start making moves. And the request does need to be, excuse me, the request is necessary for the tenant to be able to use and enjoy the dwelling. It does need to be reasonable, and reasonable is in quotes there again because it is purposefully gray. It is anything that a reasonable person would consider reasonable, right? And that always is different. But it cannot cause an undue financial or administrative burden to the housing provider. It can't change the fundamental nature of that housing. And we'll talk about that in a little bit here. If a housing provider just flat out refuses to make these, reasonable accommodations or modifications, it can be a fair housing violation. They can be denied if they're unreasonable, but the housing provider needs to actually do a little bit of research into what would be necessary to approve this request before just denying it. So The main difference between these two, a modification is a change in the physical structure, while a accommodation is a change in the policy. So for a modification, installing handrails, grab bars in the bathrooms, lowering countertops for someone in a wheelchair, installing ramps, having that kind of stuff. For an accommodation, it's having a emotional support animal or a service animal, assigning somebody a parking spot when it's normally first come, first serve, that sort of thing. So what would be unreasonable for a reasonable modification? I live in this 100-year-old townhome. Can you install an elevator in it because I'm in a wheelchair? No, I can't install an elevator in the 100-year-old townhome. But you're more than welcome to install a chair ramp on the staircase. For accommodation, one that we have had success in doing is if a tenant doesn't get their Social Security check, they're on Social Security, they have a disability, they don't get it until the 6th, the 7th, the 8th of the month. But the landlord's policy is that rent is considered late on the 5th of the month. So making the request, hey, can you not consider my rent late until the 10th because I don't get my Social Security until the 8th? That would be a reasonable accommodation request for that landlord to do. Unreasonable would be to say, hey, don't ever consider my rent late because I don't get it in time. So that's the difference there. Changing the fundamental nature of a housing provider would be with the example of a old folks, or not old folks, a 55 and older community, and making the accommodation request saying, hey, I have a disability and I'm 20 years old. Can you change your policies so that I can live in this 55 and older community? And we'll get to it later, but 55 and older communities are exempt from fair housing, but they don't need to make that reasonable accommodation request because it changes the fundamental nature of that housing. So to get to Sam's question, assistance animals. And the term assistance animal applies to both emotional support and service animals. The main difference between the two is that a service animal is trained for a specific task. It does have documentation associated with it. An emotional support animal is not trained for any task. There isn't really any documentation associated with it, but they are both necessary for the full enjoyment of that tenant's dwelling. For an emotional support animal, the tenant needs to get some kind of documentation from a health provider. It doesn't need to be a therapist or a psychiatrist, just the person who sees them the most and is the most familiar with their situation. And it just needs to say, so-and-so needs to have so-and-so animal with them at all times for emotional support and to fully enjoy their dwelling. Signed. Done. A landlord cannot ask for any medical information. They cannot ask for any diagnosis. They just need to be aware of the disability-related need for the animal. That is that there is a disability-related need for the animal. That is it. The housing provider can require that the tenant fill out a form on the animal. Height, weight, color, breed, all that fun stuff. The tenant is also still responsible for any damages that the animal causes. So if it's a emotional support dog and it's peeing on the carpet and they move out and the landlord comes in and they have to replace the carpet, the tenant's responsible for paying those costs. However, a housing provider cannot charge any additional fees, deposits, rent, anything like that for that animal. It is not a pet. Both a service and a ESA, an emotional support animal, are seen as extensions of that person with the disability. And charging them for that animal is seen as charging them for the disability. I had one landlord ask me about pet fees, right? And I said, what if I just charge them an animal fee since it's not a pet? And I was like, that's clever, but no. There's also no breed restrictions under pet policies, including insurance companies. If an insurance company says, hey, you can't have pit bulls in this house, we're not covering that, how do we actually see the insurance company here as the housing provider, and they need to make that reasonable accommodation. Now, that pit bull does end up being violent and attacking people. They need to get rid of that animal as well. So that means that, yeah, that if an animal is a direct threat to the health and safety and property of others, and again, it has to be direct, they can ask for that animal to be removed. So I have, when you use the term breed, does that mean type of animal like dog, cat? No, it means breed of dog. Um, so, Chihuahua versus Pit Bull versus Lab. So since animals do need to be a common household pet, so you can't really have a um, emotional support giraffe or alligator. Um, Landlords can accept that if they want to, they just aren't required to. For a service animal, if that animal is trained to do a specific task, it can be outside of that purview. So, for example, a monkey designed to trained to open up pill bottles. That can be a service animal in that case. Sam's asking, so if someone has a registered support animal, landlords can't charge a pet fee. Correct. If they're a registered support animal or they have that letter from the medical provider stating the need for the emotional support animal, they cannot charge a pet fee for that animal. If they have a no pets policy, they cannot deny that applicant because of that animal, because it is not a pet. It is an extension of the person with the disability, and denying the animal is the same as denying the person for having that disability. And that is a violation of the Fair Housing Law. Moving on, are there any other questions about emotional support animals that I didn't answer or anybody would like me to clarify on that? It is kind of a big thing when we get to this, especially with housing providers. Oh, can a landlord deny you an ESA because they have an allergy? The landlord has an allergy. I would say no to that. So we'll get into the exemptions then. But if a landlord falls under fair housing law, no, they would not be able to do that. Even if they're living in that building as well. In Pennsylvania, they're allowed to have one additional unit in their building that they're renting out that they also live in before they're not exempt. So if it's just me renting out a room in my house, I could deny that person just because I'm exempt from fair housing. But if I have an apartment building with 6 units in it and I live in one of them and I have an allergy to cats, you have an emotional support cat, I cannot deny that tenant. And you can get them retroactively, not retroactively, you can mid-tenancy suddenly now need an emotional support animal. Things happen in life where we need that. So they say, oh, well, hey, now you need to pay me a security deposit fee, a charge for this animal you're having moved in. Well, I don't care that it's an ESA. I am filing for eviction because I have no pet policy. That would be an example of a violation of the Fair Housing Act. So feel free to put in any more questions that you guys have. I will answer them as they come up, but I am going to shift over here to sexual orientation and gender identity. It is not a specific protected class outlined in either the federal or the state laws, but it does fall under the protected class of sex in both. So HUD will investigate complaints of sexual discrimination based on identity and orientation and enforce the Fair Housing Act. At the state level, they are considering all of the below as falling under the protected class of sex. So that's sex assigned at birth, sexual orientation, transgender identity, gender transition, gender identity, gender expression. All of these things, according to the PA Human Relations Commission, fall under the protected class of sex at the state level. So if you are running a shelter or a dwelling, you cannot deny anybody based on any of these subclasses, I'll say. So that is direct impact. Those are all examples of a housing provider who would deny somebody housing specifically because of a protected class. Disparate impact here is more so policies and procedures that are there, that are in place, that don't have a discriminatory quality to them at their surface. They don't seem discriminatory, but they have a discriminatory impact on protected classes. One that I don't believe that we have in here, that's not a broader scope, is requiring that everybody in this apartment building or apartment complex once a month pull their furniture away from the walls so that scheduled pest control can come in and spray. If somebody has a disability and is physically unable to pull their furniture away from the wall, they can't follow that policy. They can't do it. So the fair housing violation here would come in if that person was penalized for not being able to do that. Hey, you haven't done this 3 times in a row now, we are going to move to eviction. Well, they can't do it because they are disabled. So at that point, there should be a reasonable accommodation request made. The housing provider needs to work with that individual to get that furniture pulled away. So that's one example. Some of the other larger ones here are criminal records. So housing providers can require background checks. They can deny people based on their criminal records. That is allowed. HUD is requesting, recommending, encouraging, though, to look into the nature and severity of the crime, how old that record is, and any rehabilitative efforts since the conviction. So did the person get convicted of breaking and entering 10 years ago, and they had been volunteering and going to all of their PO appointments ever since? Did they get an aggravated assault charge 3 years ago? At a bar, they got into a fight, so they have an aggravated assault charge. But they've been going to AA meetings. They don't go to that part of town anymore. And it's been 3 years. Take those things into consideration. If it's arson 2 months ago and they still look at the match factory, yeah, don't approve that person. But you gotta check on exactly what that situation is. Blanket bans are not allowed. That's calling a housing provider, saying you have a criminal record, and them saying, "Oh, we don't accept anybody with criminal records. We don't accept criminal records." Arrest records can also not be used. And criminal record is not necessarily indicative of whether or not someone's going to be a good tenant. They could just have gotten in the wrong place at the wrong time, made a bad decision, and now they have a record. These blanket bans and arrest records are in place, are not allowed because people of color in the United States are much more heavily policed than not. And we're more likely to have a criminal record. And so the disparate impact here of having these blanket ban policies has a discriminant impact on race and color. How are the considerations reviewed from a fair housing standpoint? So, like I said, if a applicant is calling and saying they have a criminal record, and that particular housing provider is just saying, "Oh, we don't accept criminal records," they can come to us. We can call them, discuss what fair housing is, discuss this. And of course, they'll say, "Oh, yeah, we have this policy. Yeah, of course we do." We go on case-by-case basis. But that person would still be able to file a fair housing complaint if they wanted to, and we can assist with that. For fair housing to try to avoid that for housing providers, having a codified written policy in place for criminal records on how that is handled is very important. So have written down, no felonies within 7 years, no misdemeanor within, 5 years, 3 years, no misdemeanors within 7 years, however you want to do that, and really have that written down. Like, do you not want to accept anybody with violent crimes or serious drug charges, but are fine with accepting people with small possession charges or non-violent crimes, that sort of thing. So have that written down, have it codified, and be able to show an investigator if a fair housing complaint is filed, show the investigator what that policy is And then you also need to be able to show as a housing provider that you're following the policy. Because having a policy written down, if you're not following it, that's still a violation of fair housing law. So some examples here, leasing agent only requires certain applicants to undergo criminal background checks. So having a black applicant go into a background check, but allowing the white applicant just to get by. Making arrest records part of your decision. If somebody has a criminal record related to disability, they can request a reasonable accommodation to avoid that record screening. But if they're denied, that is a violation. Applicants, like I said, discouraged from submitting an application because they have a criminal record. Also, domestic violence is in here as well. So if a property manager tells a tenant they need to move or won't rent to an applicant because they've been arrested for or are a victim of domestic violence, that is also a violation of the fair housing law. So source of income, there's only 2 places in the country, well, I almost said the country, in the state, 2 places in the state that have source of income protection. I believe that is Philadelphia and State College. So when I was doing, housing location work, looking for housing for people, I would say include your wages, your Social Security, your child support, your alimony, anything that has money coming in to you, put that on as to include in your income. Lancaster County and York County are not source of income protected classes or protected areas. But there could be, some landlords will say, well, I don't accept Section 8. I don't accept Social Security. I don't accept child support, that sort of thing. I only want earned income wages to count towards somebody's income, when they're setting that 3 times the amount. This can have a disparate impact, though, if a landlord denies child support. If that's child support because I have a family, then that could be based on their status. If they're denying you because you only get Social Security, even though it's enough to make the unit, you might be discriminating against age because age is a protected class at the state level, or disability. Occupancy limits. This is a fun one. So HUD recognizes that property managers can set occupancy limits, but has guidance on the flexibility of that. Does the unit have large bedrooms? Does the unit have a den or like an office space that can't be classified as a bedroom, from a realty point of view, but could be used as one? And then what laws do local municipalities have? So if you ever encounter this, if this is ever something that's happening, oh, well, there's too many people for this size of house, go to the municipality first, see if they have anything on the books, because the housing provider, the landlord, should be following those local laws. So if they have something on the books, the landlord should be following them. But if that municipality has a overly restrictive occupancy law, they could be in violation of the Fair Housing Act. And you can file a complaint against them specifically. Typically, the idea is 2 heartbeats per bedroom. That's typically what the general rule is. A lot of municipalities and landlords will use the International Occupancy Standards or Construction Standards codes, which per bedroom, I believe it's 70 square feet for the first person, and then 50 square feet for each additional person beyond that. But again, even if that's on the books, they will still say, oh, 2 people, 1 bedroom, cool. One thing to note is that discrimination based on familial status here, if they have a family has an 8-year-old son and a 17-year-old daughter, and they're looking to rent a 2-bedroom unit. And the landlord says, oh, well, no, they need to be in separate rooms. You can't have an 8-year-old son, a boy, sharing a room with a 17-year-old girl. You can't do that. That is also discrimination based on familial status. They are denying them that housing, making them look for a 3-bedroom, possibly setting them out of their price range. It is up to the family how they house their family. Additionally, along those lines, if a single parent and their child rent a 1-bedroom home, that's 2 people, 1 bedroom, that qualifies. But that mom wants them to have their own space, so they decide to sleep in the living room and use the living room as their bedroom. That is allowed, as long as all the egress laws are being followed and they're not moving additional people in and treating it like a 2-bedroom unit. And That is allowed. Like I said, there's no difference between putting a bed in that living room or a couch in that living room. And I have encountered that before too. Nuisance ordinances. So this one usually is directly on municipalities. So we've all heard about that. If you get the police called 3 times in a calendar year, the landlord needs to evict that tenant. Sure, but I had an instance where the police, a downstairs tenant called the police 4 times in 6 months on his upstairs neighbor because they had 3 kids. And upstairs neighbors allowed. They just are. And so he called 4 times in 6 months, and the landlord decided to file for eviction. Was not being required to by the municipality, but decided, hey, that's 4 times, you're getting evicted. Luckily, the judge threw that case out because there were no police reports about noise complaints. Because these complaints are typically for loud parties at 2 in the morning, right? What they do is they have an impact on families with kids. They have an impact on domestic violence survivors calling the police on themselves so they can get help from for their abuser and then subsequently being evicted because of the ordinance. So that's something that could be a disparate impact on people. And again, municipalities can have fair housing complaints filed against them for these ordinances. So domestic violence case study, we had one here. This person had stopped calling the police because of the nuisance ordinances. And the landlord provided her with her move out notice while she was in the hospital because her abuser put her there. They filed a fair housing complaint. She was awarded $11,000. The landlord had to add a clause to the lease about all he had to do was let her out of her lease without any consequences, and that was it. So he had to add a clause in the lease to, kind of state what that process looks like and do a fair housing training. So with this, you still need to have, letters from a domestic violence shelter, from a caseworker or something, a police report, to show that you are a domestic violence survivor, that you are fleeing a unit because of that. But the landlord should let those tenants out of their lease without consequence. They should not be evicting them because the police were called X amount of times. Oh, I clicked the wrong arrow. So, not everybody. So we already determined, that fair housing law only applies to people who live in a dwelling or a residence. But even there are still exemptions for those who do not live who do live in a dwelling, but are still exempt from fair housing law. There's a single family residence exemption. So that's a sale or rental of a single family home, those row homes, those standalone homes. At the federal level, this means that if an owner does not own or have interest in more than 3 single family homes besides his own at one time, they are exempt from fair housing law. And he also cannot use the services of a real estate agent or broker, or if he's renting, a property manager. Because at that point, the real estate agent, the broker, that's seen as the person who is the housing provider. The property manager is the person with the housing provider. And they have more than 3, for sure. At the state level, the state does not recognize this exemption. So if I own my home and I own one other home down the street, under the PA Human Relations Act, I am not exempt from fair housing law. Those are housing for older persons. So there have to be policies and procedures in place, right, that demonstrate that this housing is a 55 and older or 65 and older community. I can't, as a housing provider, arbitrarily say, well, I'm a 55 and older community now. I'm only going to rent to people who are over 55. No, I have to have policies, procedures that demonstrate that, funding sources, that sort of thing. There's also Miss Murphy's exemption, which is similar to the single family residence, but this is an owner-occupied dwelling that includes housing for no more than 4 families living independently. So that's an apartment building where what happens if there are 2 people with disabilities living in adjoining apartments and the disabilities collide? For example, One person has PTSD and is sound sensitive, and the second neighbor has a disability that causes them to talk loud and shout from tics. What is the responsibility of the landlords for each disabled tenant? So that's also somewhat similar to perhaps another tenant discriminating against their neighbor, another tenant, for any other kind of protected class. So under the PA tenant landlord law, each tenant has the right to do it's called the covenant of quiet enjoyment. They can enjoy their unit peacefully, quietly, by law. So if one tenant is not allowing that to happen, so I'll get to the disability case here in a second. But if one tenant is screaming obscenities about race, racial slurs to another tenant, the landlord has the responsibility to enforce that peaceful covenant of quiet enjoyment. And if they don't, they can be subject to fair housing law, because they know this person is discriminating against the other tenant. They have a legal recourse to end that discrimination, and they are not taking it. So similarly with in this case, both the tenant with the PTSD and both the tenant that talks loud and shouts have the right to a peaceful covenant of quiet enjoyment of their units. So it really comes down to if one is being specifically a direct threat to the health and safety of the other. A reasonable modification for the PTSD folk would be, hey, could I install noise canceling pads in my apartment so that I can't hear the person shouting loud and talking? For the person who talks loud and shouts, it's tough. So yeah, fair housing law gets complicated very quickly. It can in this case. What the landlord would not be allowed to do would just evict one of them. Well, he's got tics, so I'm trying to make sure my PTS tenant is satisfied. So I want to evict him. And they can't evict he's talking loud and shouting from that disability. So eventually he could evict. Hoarding is also considered a disability. But at the same time, it can be a health risk for that tenant and others just based on the amount of stuff involved. So in that case, the landlord needs to give them time, work with them, figure out a solution to the situation, and not just evict them right away. So in the same case here, the landlord would have to try to figure out some kind of workable solution, some kind of reasonable accommodation or modification for these two tenants before they decide just to evict one or the other. Now, if one of them was becoming a direct threat to the health and safety of the other due to their disability, that would be, at that point, the landlord would be within their right to ask that particular tenant to leave. But it does get complicated. What is reasonable? What's a reasonable amount of time? What's a reasonable modification or accommodation request in this case? Can the PTSD tenant just buy noise canceling headphones, and every time he starts hearing a trigger, put them on, and so he doesn't hear them? Can the tenant who is has the tics, if he ever feels them coming on, depending on the severity of it, can he go for a walk? That sort of thing. Or can he install the noise canceling pads in his apartment so the sound doesn't get out? So it is tricky. There's no hard, fast answer for that one. So for Miss Murphy's exemption, that's an apartment building with I'm the landlord, I'm living in one of the apartments, and I have 3 other apartment units in my building. If I have 3 other units and I'm living in one, at the federal level, I'm exempt from fair housing law. At the state level, however, that is reduced to 2. So that is my unit and 1 other unit. So if I have 3 units in the building, I am no longer exempt from fair housing law. This also falls into the usage of a property management company. If I use a property management company for that 1 unit, I am no longer exempt because they are seen as the housing provider, and I cannot discriminate in any of my advertising. Religious organizations also have an exemption. If they own a building, a house, a home, they can show a preference for members of their religion. They can't operate this building for profit. They cannot discriminate based on any of the other protected classes. And again, they cannot advertise or use a property management company in any advertise in a discriminatory way, or they use a property management company to manage it, they are no longer exempt as well. But those are the 4 exemptions to fair housing law, and those are the only 4. So this is the fair housing complaint process. So we are a FIP with an education and outreach initiatives grant. So we don't actually do this process, but what we can do is if somebody feels like they've been a victim of discrimination, they can come to us. We can help them file a complaint with either HUD or the state. Once we do file, the investigative agency takes over. They will do an intake. So they will call the person who is filing the complaint is called the complainant, and the housing provider or the person they're filing a complaint on is the respondent. So they'll call the complainant, interview them, get information, figure out what's going on. They will then call the respondent and ask them questions and get information from them. During that investigation, they will try to bring the 2 parties together for a conciliation. So in the case of, well, this person, they were really standoffish when I came in to drop off my application. By the phone, they sounded great, and then I got denied the unit somehow. I don't know why. So that conciliation is like, what do you want out of this? Well, I want to be accepted into the unit, and so that conciliation would simply be the landlord approving them for the unit based on their other qualifications. But they try to come up with some sort of agreement between the 2. If there's no agreement that can be come to, no agreement signed, and the investigation determines that there was most likely a fair housing violation, it does go to court. And I believe it's a complainant can decide if it's heard in a United States District Court or a HUD administrative law judge. And there's no cost to the complaint at this point either. So the case is heard, and then it's closed after it's heard, whether in the case of the complainant or the respondent. There's also a timeline for these. So to file at the state level, it's 180 days after the last instance of discrimination. And at HUD, it is 1 year. So that is so if somebody's being displaced from their home or they're looking for housing and they believe it's due to discrimination, they have time to go figure out what they're doing. They can go find housing, they can get secure, they can get safe, and if they want to, go back and file this complaint against that previous housing provider. So like I said, how can we help? We do this, provide information about rights and responsibilities. We give the same information to landlords, housing providers, tenants, because it's the information they all need to know. We can assist with reasonable accommodations and modification requests. We can help to mediate between landlords and tenants. Have had some success with writing letters to housing providers, kind of just explaining the situation and explaining what their rights and responsibilities are in that situation. And like I said before, we can also assist with the actual filing of the fair housing complaint, whether it's at the state or the federal level. We usually determine that based on the urgency of the matter. The state's usually a bit faster. These are seen in separate courts from eviction hearings, so they don't stop evictions. So if somebody thinks it's going to stop their eviction, it's most likely not going to, because the eviction court's much faster. But we can still file that complaint with the state. If it's a discrimination complaint based on age, we'll file with the state because age is not a protected class at the federal level. But if it's over that 6-month time frame, then we'll most likely file with HUD because it's already past the state statute of limitations there. You can feel free to stay connected with us here, online, all over the place, LinkedIn, Twitter, Instagram, Facebook, and our website, wearetenfold.org. There's a lot of different workshops and classes there for clients. Our financial workshops are there. We have a bunch of our rental workshops as well for Housing 101. We talk about how to look for housing. We talk about, we go into the tenant landlord law more specifically. This was more focused on fair housing, but we do a workshop where we go over the Tenant Landlord Act, mostly as a way to describe what a tenant's and a landlord's rights and responsibilities are in regards to the rental relationship. And also we have one that's lease basics. We just go over a lease. We go in depth about what should be on a lease, what can't be on a lease, and really try to drive home the importance of reviewing and understanding a lease. And then here's our contact information. That's the top there. Justina Cruz is our Fair Housing Outreach Manager for Lancaster County here. You all know Mark Unger, not only in his work as the chair of the COC, he is also a York Rental Stability Manager down in the York office. And we have a Fair Housing intake line as well that anybody can call with a question, with a comment. Well, comment's fine, but if you have a question, feel free to call. And we will do our best to provide you with the information that you need. I'll leave this up here so you guys have it and can take it down. But that is all I have for today. Thanks everybody for having me, for taking the time to listen on this Friday morning. I really appreciate it. Thanks.
Thanks so much, Jeremy. You did a great job of keeping up with all your questions. I appreciate that. I just wanted to give just one more minute, see if anybody else was typing anything.
Yep.
Oh, there's something.
You're welcome, Holly.
Oh, wonderful. Okay. You have amazing contact information here. In the off chance that you don't have it, you can request it from me.
Yep.
And as soon as our recording is processed, everyone who registered for today will automatically get the link. We will also send it to the York County Coalition on Homelessness mailing address, or mailing distribution list, I should say. And then, yeah, make sure you review it within the next 30 days. Thank you so much, Jeremy.
Yep, of course.
Take care, everyone.
Have a good one.